All right, well, welcome everyone to today's webinar relating to opposition proceedings involving Madrid protocol applications. My name's Tim Stevenson. I'm a member of the Trademarks Opposition Board, and I'll be co-hosting the webinar today with fellow board member and colleague Natalie DePaulson. I'd also like to make a special acknowledgement to Eric Dupont and Maxime Arsenault, two of the managers on the opposition board for their help today in setting up the webinar and all of the logistics. I'll get started by acknowledging that since I live and work in the Ottawa-Gatineau region, I'm on the traditional unceded territory of the Algonquin Anishinaabe people. And since we're convening today virtually, I recognize that others may be on different Indigenous lands. Just a few logistics at the outset. Natalie and I will be presenting today in English. We have simultaneous translation available in French. And so on your screen, in the lower right-hand corner of the Zoom screen, there should be a globe icon. And if you click on that, you can toggle between English and the simultaneous French translation. The slides today are in both English and French. Wherever possible, we've tried to include both languages on the same slide. Where we couldn't, we've included it on sequential slides. The presentation should be in the neighborhood of about 40 or 45 minutes with a question period at the end. For the questions, please use the Q&A function again at the lower right of your screen to enter your questions. Please use that function rather than the chat box. And also, please feel free to include the questions in either English or French. The overall purpose of the webinar today is to give an update on where we are in terms of the volume of Madrid applications that the board is considering, and also to give an idea of at least what the board considers some good or best practices when it comes to opposing Madrid applications, particularly with respect to requesting extensions of time and filing statements of opposition. We're also going to try to provide an idea of some of the underpinnings of the opposition system to Madrid applications, particularly why the regulations are the way they are with reference to individual aspects of the protocol. So let's jump in and go to the next slide. There we go. And I do apologize on behalf of us all for the little logistical hiccup at the outset. In any event, so here are some recent statistics as of November of this year. And so we've set out the total number of protocol applications designating Canada, the number that have been advertised, and the number that have been opposed. And with respect to the third row, those that have been opposed, we're including there both matters where a statement of opposition has been filed and also proceedings for which an extension of time to oppose has been requested. And so at least for advertised protocol applications, this right now represents an opposition rate of 1.2%. That doesn't appear to be higher than historic opposition rates, but the big qualifier at this stage is we're in very early days. This may well not be a representative sample at this point. And when I checked a few days ago, it appeared that the opposition proceeding that was furthest along, an opposition with a Madrid application that was furthest along, was still in the evidence phase of the proceeding and still early in the evidence phase of the proceeding, specifically the opponent's evidence stage. So let's move to the next slide, if we can. So the first procedural point we wanted to cover is extensions of time before filing a statement of opposition. And I do want to be clear that all of the next series of slides relate to extensions of time before the statement of opposition is filed. And as most of you will be aware, historically, before filing a statement of opposition, there were multiple extensions of time available. You have the benchmark, the cooling off, the exceptional circumstances in certain situations, and retroactive extensions of time, provided you meet the requisite test for a retroactive extension. And I think justifiably, practitioners are probably used to a certain degree of flexibility and discretion being exercised on the part of the board when it comes to these extensions of time, particularly in situations like exceptional circumstances or retroactive extensions. And again, on this point, I want to be clear that all remains the case for domestic non-protocol applications. But there's a but coming here. If we can move to the next slide. The situation is different for protocol applications, and the extensions of time that are available to a prospective opponent to a protocol application are more limited than they are to a domestic application. And in particular, with Madrid applications, we can only grant an extension of time of up to 4 months from the initial opposition deadline. So that's the end of the 2-month advertisement period. And we cannot grant an extension of time that goes beyond that 4 months. And so the theme to a number of these slides is that this is a hard deadline and will need to be docketed as such. So let's move to, perfect. So why are we restricted to this 4-month extension of time? We're not going beyond 4 months. And this is the reason. This is section 125 of the regulations. And I won't read it through verbatim here, but I've underlined the most pertinent parts. The registrar is not permitted to extend under section 47 of the Act, the standard 2-month advertisement period by more than 4 months. So this is the prohibition in section 125. And we'll just move to the next slide with the French language. And so with respect to section 125 and requests that might come in, you've just got to keep in mind, if you're potentially wanting to oppose a Madrid application and you've already secured the 4-month extension that is permitted, if you think you have good reasons for either a longer extension than 4 months or a further extension, it's not that the board doesn't understand or sympathize with the circumstances. It's that section 125 prohibits us from granting that extension. And so the next question might be, well, why is section 125 in the regulations? And if we can move to the next slide, this is the reason why. So this is Article 5 sub 2 sub C of the Madrid Protocol. And again, I won't go through this verbatim. And I will note that the sub II section at the bottom and the portion that I've highlighted, this is right now the relevant provision of the Madrid Protocol, taking into account the current examination timelines in Canada. But what this provision of Madrid sets out is there's a 7-month deadline from the date the opposition period starts. So that's the advertisement date. There's a 7-month deadline during which, if there's any opposition proceeding, the opposition board has to notify the International Bureau. And so there's a 7-month fixed window. And it's worth, perhaps we'll move to the next slide. It's worth noting generally, one of the purposes of the Madrid Protocol is to push applications forward on certain fixed timelines in the absence of certain other steps that might be taken, one of which is the filing of a statement of opposition. So part of the goal of the Madrid is to push applications forward to the registration in the absence of certain other steps. And So ultimately with 5 sub 2 sub C, the opposition board has to notify the International Bureau within 7 months of the start of the opposition period if there is any opposition. If we don't provide that notice to the International Bureau, the application automatically proceeds to registration. So this slide is meant to demonstrate how it all fits together, and again, to highlight part of the reason why Section 125 of the regulations limits the extension to 4 months. And so again, keeping in mind the 7-month window that's permitted by the protocol, you have the advertisement date, you have the 2-month standard period to oppose. Then what was chosen under Section 125 was a 4-month extension of time being available. And then finally, you have the limit of 4 months, because that affords the opposition board 1 month to receive, process any statement of opposition and to notify the International Bureau of that opposition. So ultimately, Section 125, it ensures that the opponent or prospective opponent obtains an extension of time, has an extension of time available. And then it also ensures that the board has the 1-month period to accept and process and forward any statement of opposition to the International Bureau. So we thought it would be worthwhile to quickly run through a few examples just to show how this all plays out in practice. The first example is entirely straightforward. And if you want to play along, you could ignore the third bullet point and see if you can identify the correct answer. But so for this one, let's take an application that's advertised on October 15th of this year. The initial opposition deadline is going to be December 15th. The opponent requests a 4-month benchmark extension under 47 sub 1. Can we grant that extension? Yes, we can. That's the 4-month maximum permitted for a Madrid application. This extension request is totally fine. For example, number 2, and so this is essentially the same application advertised on October 15th. The initial deadline would have been December 15th of 2021. Let's say that due to an inadvertent and innocent docketing error, that initial deadline of December 15th was missed. It was caught on December 17th, and the opponent requests a retroactive 4-month extension of time to oppose. This extension can be granted. And there's 2 points that we wanted to make with respect to this example. The first is for Madrid applications, for extensions before the filing of statement of opposition, the board can still grant retroactive extensions of time. What we can't do is grant a retroactive extension of time that extends the deadline beyond that 4-month limitation. So in this case, the request is made because the initial deadline to oppose, that's what was missed. We can still grant a retroactive 4-month extension of time, provided it otherwise meets the requirements of the Act, specifically that missing it wasn't reasonably avoidable. The second point that I wanted to make on this example, and this is a bit of a digression into the nature of a retroactive extension of time. I think it is important to understand that when the board grants a retroactive extension of time, it can go back to a missed deadline and grant an extension of time that brings the party up until the present day, or in this case, in this example, a time in the future. What a retroactive extension of time does not do is it does not backdate a document. So for example, in many cases, retroactive extensions of time are requested, and at the same time as making the request, a statement of opposition is filed or evidence is filed. And If all the requisite tests are met, the board can grant a retroactive extension of time, but that extension, it brings you up until the present day. It doesn't backdate your statement of opposition or backdate the date of your evidence. So taking example 2, again, if on December 17th, for example, instead of the opponent requesting a retroactive 4-month extension of time, they were requested a retroactive 2-day extension of time, and included with that request the statement of opposition that they wish to file. In that case, again, the extension of time can be granted, the retroactive extension can be granted, but the date of your statement of opposition is still December 17th. It doesn't backdate your statement of opposition to the earlier missed deadline. Okay, so the third example, and this one, again, I think should be pretty straightforward. So we'll take an application advertised on May 10th. Initial deadline to oppose was July 10th. The opponent secures the benchmark 4-month extension of time until November 10th, so that's fine. But then on November 10th, they request a 9-month cooling off extension. And the short answer here is obviously this cannot be granted. That would be in violation of section 125 of the regs. We would be granting more than 4 months. So we can't grant that. Let's maybe move to the next slide. This again is the same example, but I'll put a slightly different spin on it. Let's say at that extended deadline of November 10th, instead of requesting a 9-month cooling off, the opponent requests a 3-month exceptional circumstances extension of time on the basis that they just took over as the new agent on the file, something along those lines. Again, you've got to understand that we cannot grant that extension of time. Section 125 prohibits us from doing that. We cannot extend the deadline beyond 4 months. So again, in that circumstance, we cannot grant that extension. All right, so this is the last example, and this is much the same application as the previous one. We've got initial opposition deadline of July 10th, secure a 4-month extension till November 10th. And so just again, to demonstrate the nature of this hard deadline, let's envision a situation where for whatever reason that November 10th deadline is missed. On November 17th, a week later, the opponent requests a retroactive 1-week extension of time, and at the same time files their statement of opposition. Again, this is a circumstance where the board's position is we cannot grant that extension of time. And this gets back to the point I made earlier about retroactive extensions of time. It permits us to go back and extend the deadline up until the present day. It does not backdate your statement of opposition or deem it filed at an earlier date than it actually was. And to be fair, at least to my understanding, that has always been the manner in which the board has treated retroactive extension requests. It has never been a means to backdate a document. It just permits the filing by extending the deadline up until the present day. So the takeaways then from this first portion of the presentation, I think are very straightforward. You've got to know that when you're dealing with protocol applications, the availability of extensions before you file the statement of opposition is more limited. And that 4-month extension that is available, that is a hard deadline. The board's position is it cannot be extended. And for docketing purposes, it's obviously something that's very important to keep in mind. So I think with that, I'll turn things over to Natalie.
So I just wanted to jump in, Tim, because there are some questions coming through in the chat, and to let all of the participants know that we were asked by the interpreters to save questions until the end of the webinar and then return to the slides. And so I think our plan is to do that. So we certainly invite questions, and in fact have left the bulk of the time, at least 20 minutes, to answer the questions. And any questions we can't answer, when we post the recording of the webinar, we will include answers to the questions that remain unanswered, if any, at that time. And so the next portion of the webinar is going to focus on the statement of opposition and some differences that exist between statements of opposition requirements for domestic applications and statement of opposition requirements for Madrid applications or protocol applications. The statement of opposition forms the basis for a provisional refusal based on opposition. Rule 17 of the Madrid Protocol regulations, the regulations under the protocol, include the IB requirements for a provisional refusal based on opposition. These requirements include the opponent's name and address, and the particulars of any relied upon trademarks, including the trademarks, any application and registration numbers, and the goods and services. So this is one departure that's a little bit different from what we may see in a domestic application and a statement of opposition against it. Oftentimes a 12(1)D ground, for example, may include just the marks and the registration numbers. But for a provisional refusal based on opposition, that would not provide all of the information required in Rule 17 because the goods and services would be missing. The provisional refusal sent to the IB must also include all of the grounds of opposition on which it is based and reference to the provisions or sections of the law. So that would include, if it was section 12(1)D, the section 30, also section 38, the general provisions with respect to opposition. Finally, the registrar must also include the time limit to respond, which will be the deadline for the applicant to file a counterstatement or request an extension of time to do so. There are some requirements in the regulations that a statement of opposition be in English or French and be filed using our e-services system. And the requirement to be in English or in French is to assist with the assignment of the correct team at the IB who reviews the provisional refusal to ensure that it has been filed on time and meets the requirements in section 17. So there really is an examiner at IB. We have a team of examiners that are looking at the provisional refusals on to oppositions and are checking them to make sure that they comply with the International Bureau and WIPO's rules. So the requirement for the e-services system ensures that we will meet our deadline to notify the IB. It eliminates risks of lost mail or handling, and it assists in avoiding errors because the requirements for the provisional refusal, such as the essential provisions of the law and particulars of the trademark, are populated directly. So for the grounds of opposition, these are pulled, the grounds of opposition are pulled from the e-services that people fill out when they're on the form, potential opponents. And for the particulars, if you have a ground of opposition that is based on a prior application or registration, you are prompted to enter the numbers for these applications or registrations. And then we pull all the information that the IB requires from Intrepid and include it in the provisional refusal. Section 127 of the regulations requires the registrar to send to the IB a notification of provisional refusal if a statement of opposition is filed. And so one thing that has come up in a few of the cases that we've seen before is that the e-services form is used And a second PDF entitled Statement of Opposition is also attached using the document attach field to this. So what we're seeing is the e-services form is populated with the grounds, typically in these situations. The relied upon applications and registration numbers are also included in the e-services, and the document entitled Statement of Opposition would look very similar to the statements of opposition that are often seen on domestic applications. And we wanted to take a couple seconds during the webinar to caution that doing this or simply stating see the ground in the attached statement of opposition has some risk. The first is that if there are application or registration particulars that are in the attached statement of opposition, but not the e-services form, this means that they cannot be relied upon to refuse an application because we have not provided the requisite information to WIPO. We are not looking in the attached statements of opposition to verify that they match up with the numbers that are in the e-services. Secondly, there may be some differences in the grounds of opposition between both. And I thought it may be helpful for people to see what the provisional refusal looks like. So this is one that we have sent to the IB. Of course, the office making the notification is included, the name of the holder, the name of the opponent, and address of the opponent, where it says information concerning the scope of the provisional refusal. It's a total provisional refusal affecting all the goods or services. That's indicated because some countries do partial refusals, whereby part of the mark is refused and the rest of the mark that isn't goes ahead. And so you'll see in part, it matches up with some of the information that's required in section 38.3, such as the name and address of the opponent. Then there is a section called grounds for refusal. That is pulled directly from the e-services entries that opponents make, where they select the different grounds of opposition and are prompted to provide certain information. We would include that information here. In step 7, it says information relating to the earlier marks. And if in this case, there were earlier marks that had been relied upon, this table would appear with the information for each mark. For the corresponding sections of the applicable law, this is what is generated as the last part of the provisional refusal based on opposition. And what it pulls out is all of the sections of the law that correspond to what has been selected in the e-services for each of the grounds of opposition. And again, this would be a requirement from Rule 17 of the regulations for the Madrid Protocol, and would be an additional or different requirement than we would typically see for domestic applications. And all of the information in the provisional refusal then is sent to the IB, including the information relating to the possibility to request a review or file an appeal. In the case of Canada, this is the counterstatement deadline. And we indicate that the review or appeal must go to the Registrar of Trademarks. The correspondence must be in English or French. And with respect to a counterstatement, there aren't really any requirements. It's in the coming into force of the Act, that's settled. We list that it's the Registrar of Trademarks who's sending the notification and the date that it's sent to the International Bureau. Now, as I mentioned, once it receives the notification of the provisional refusal, the provisional refusal is reviewed by an examiner at WIPO. If it is out of time, or if one of the requirements in Rule 17 is not met, WIPO will issue an irregularity. If it's out of time, there is nothing that can be done to remedy the irregularity, and the provisional refusal based on opposition will not be recorded. If it is a problem that CIPO can rectify, we will rectify it directly. So if, for example, there's a technical glitch where the date for the counter statement isn't provided, or it's 3 months previous, we would simply correct that directly with WIPO. If we require information from the opponent, we will contact them and provide them with a brief period of time, hopefully 2 weeks, from which to respond to the office so that we can respond to WIPO. And it's a very brief period of time that we would have to respond to irregularities. It's set out in Rule 17, the period of time is 2 months, but the correspondence from WIPO, it takes 3 or 4 weeks to reach CIPO. So it is then quite a quick turnaround to address any potential irregularities. So one of the things that we also want to flag, so moving away from the provisional refusal and statement of opposition, is the new ground of opposition. There is a new ground of opposition set out in the trademarks regulations. It's section 104 of the trademark regulations, and it is if the goods and services in the protocol application are not within the scope of the international registration, then that trademark is not registrable. And this can occur over time if there are changes to either the international registration or the protocol application. Because the entitlement to a protocol application flows from the international registration, the scope of the protocol application must fall within the scope of the international registration. So after the statement of opposition has been forwarded and the provisional refusal accepted and recorded by the IB, the opposition will generally follow the usual process until a decision is reached and the appeal period has expired. There are a few exceptions to this. There's the prohibition against no new grounds of opposition, the ability to amend applications with either CIPO or the International Bureau. And during the course of an opposition, we may receive communications from the IB resulting in amendment or withdrawal of the application, and in which case, after that initial statement of opposition deadline has passed, those circumstances could form the basis for an exceptional circumstances request. So for example, if a party knows the applicant has filed a limitation with the IB, removing several classes from their application, and there are settlement negotiations ongoing and the parties are waiting for settlement, for confirmation of the limitation before the opposition is withdrawn, that could form the basis of an exceptional circumstances request for a party's next evidence deadline or a deadline to file written arguments. So now each of these exceptions we'll go through in a little more detail. So the practice notice provides that there's no new grounds of opposition are permitted, as well as section 128 of the regulations, which state that if a registrar sends to the International Bureau a notification of provisional refusal based on opposition, the statement of opposition may not be amended to add a new ground of opposition. The reason for this is that if new grounds were added, they'd be well outside that very strict time limit that Tim discussed in Article 5.2c for the provisional refusal. Now, the registrar may consider an amendment to an existing ground to be a new ground if the amendment substantially changes the basis on which the ground was originally pleaded. And assessing whether an amendment to seek to add a new ground of opposition, the statement of opposition as a whole will be considered. And there is an exception here with respect to section 12(1)(d), opposition grounds. An amendment to include an additional registration in a section 12(1)(d) ground will not be considered a new ground of opposition so long as the corresponding application was referenced in the statement of opposition. And that's because if the application particulars have been provided, then the applicant had notice of the basis of one of this mark that will be added to section 12(1)(d) at the time the provisional refusal based on opposition has been sent to the IB. So that's the first exception, a bar on adding new grounds of opposition. The second exception is amending applications. So another difference between opposition practice for domestic applications and protocol applications is that protocol applications may typically be amended in one of two ways: by filing a revised application with the office, or limiting the international registration by filing a limitation with WIPO through the WIPO representative. Once in opposition, you can file a revised application with SIPO if an office action or a statement of opposition has issued. And I'll just flag the processing time is 2 weeks to 1 month, so it can be pretty quick. With respect to the filing of a revised application, though, there is a condition. It's only possible if the office action or statement of opposition is issued. And this is because we only can file a statement of grant of protection with the IB if there's been notification of provisional refusal. And that's what allows us to tell the IB, actually, while classes 3, 5, and 7 request was protected, we ended up only protecting in classes 3 or 5. If there are no provisional refusals, so no office action, no statement of opposition, the IB only permits you to grant protection to the mark as a whole. So in that case, limitations must be filed with the IB. And right now, with respect to limitations, the processing time seems to be about 4 to 6 weeks. So the next difference is that there can be exceptional circumstances requests based on communications from the IB or the applicant to the IB for a protocol application, including where the trademark is the subject of a correction, a limitation, cancellation, or transformation. And this is simply for efficiency, so that we'll allow any changes of the application to occur before moving on to the next stage of the opposition. I will flag once again that this does not apply for the statement of opposition deadline. That is fixed by our regulations, by Article 5.2 of the protocol, and there is no ability for the office to request that the length of time for a provisional refusal to be filed be extended. For example, if the mark was being canceled and that was, both parties had that knowledge and the registrar had that knowledge, there's still that strict deadline to file the provisional refusal. For the remainder of the deadlines in an opposition, though, communications with the IB to the IB can form the basis for a provisional refusal. The next slide, what this slide is showing is what happens when a proceeding ends. So according to Rule 18-ter of the Protocol Regulations, once a notification of provisional refusal has been sent, the office must send one of two communications to the IB. A statement of grant of protection, which sets out the goods and services for which protection has been granted, or a confirmation of total provisional refusal. And one thing that's very different than the treatment of domestic applications and Canada's system is there is no concept of abandonment. So with domestic applications, our database will reflect that they're abandoned. With respect to the IB, we cannot send something that says this mark has been abandoned, and the IB does not have that concept of putting on their Madrid monitor the abandonment of a mark. Simply what would be sent would be the confirmation of total provisional refusal. And so the second part of this chart goes on: if an opposition is withdrawn or deemed withdrawn and the mark registers, a registration certificate will issue and a statement of grant of protection will be sent. It's the same for a split decision where a mark is refused for some goods and services and registered for others. Because it is going to register for some, then the statement of grant of protection is just sent for those particular goods or services for which the opposition has been rejected. And there's no real notice of the partial refusal that goes. Rather, it's a smaller statement of grant of protection. So the section of the Canadian regulations which deal with abandonment and deemed abandonment are sections 119 and 130 of the regulations. Section 119 states that if a protocol application is abandoned under section 36, a confirmation of provisional refusal must be sent to the IB. And section 130 indicates that the register must send a statement of confirmation of total provisional refusal if an application is deemed abandoned. If an applicant would prefer, rather than having an application be abandoned and then a confirmation of total provisional refusal being sent to the IB, it can request renunciation of the international registration in respect of Canada. So that is the holder of the international registration saying to the IB, filing with the IB a notice that protection is no longer sought in respect of Canada, and then IB would notify CIPO and the application would be abandoned. And this, again, similar to limitations, we're seeing that this does take 3, 4, 6 weeks to receive notice of these requests to the IB, have them processed, and then sent to Canada to be acted on. Section 130 of the regulations confirms that the register must send a confirmation of total provisional refusal if the register refuses the protocol application under section 3812 of the Act for all the goods and services. And this goes once the decision is final. So once that appeal period has passed, or if there's subsequent appeals once there is a final decision. And on the next slide, so this is actually taken directly from our practice notice because the board has received quite a few questions about what correspondence and is going to the World Intellectual Property Office, and in particular to be filed, to be forwarded to the WIPO representative versus what would go to a trademark agent, a Canadian trademark agent appointed in respect of the application. And so the statement of opposition will be sent to the trademark agent, but it is not sent to WIPO. The notification of provisional refusal is sent to both WIPO and to the trademark agent. Correspondence that occurs during the course of an opposition proceeding is sent to the appointed trademark agent. but is not sent to WIPO. WIPO is actually very strict in the correspondence it wants to receive. It's quite limited, and the communications are set out. They would like the notification of provisional refusals, the statements of grant of protection, the confirmation of provisional refusals, etc. So with respect to an opposition decision, it is not sent to the IB. What the IB wants to see is the statement of grant of protection or the confirmation of provisional refusal. Now, you'll see a strikeout noted with respect to accompanied by a copy of the confirmation of total provisional refusal. It is an error in our practice notice, and it will be corrected shortly. But because we're waiting till a decision is final, the decision will be sent first. And then once it's final, a copy of the statement of grant of protection or the confirmation of total provisional refusal will be sent to the Canadian trademark agent. Now, because as Tim said, we're only at the evidence stage, we're a long, long way from having a Section 45 proceeding in respect of a protocol application. But in respect of that, the WIPO would not get any notice that a Section 45 notice had been issued, nor would it get correspondence. What WIPO would receive is if a Section 45 notice is successful and results in the expungement of one or more goods or services, then we would send an invalidation of registration, full if it's the entire registration, or partial. And we're on our next slide, and hopefully we went a little over time, but I think we have still lots of time for questions.
Yep, Natalie, maybe I can jump in with a couple of the questions that I've been reviewing. And for the first one that I was going to address, if it's possible, Natalie, can we, if perhaps just while I'm speaking, if you can bring the slides back to slide number 13. And this again relates to a couple of the examples that I provided with respect to the limits on extensions of time. Perfect. Okay. So one of the questions that came in was a retroactive extension of 2 days acceptable, but not a retroactive extension of time as a week. And I just want to make sure that this is clear as between the two examples. So in example number 2 here, where we indicate that a retroactive extension of time can be granted, this is in a circumstance where the deadline that was missed, and in this case, it was missed by 2 days. The deadline that was missed was that initial opposition deadline. So the 2 months from the date of advertisement. And in that circumstance, if that date is missed and otherwise the prospective opponent meets the test for a retroactive extension of time, we can grant that as we did in the past, because that would not result in an extension going beyond that 4-month limitation. The comparison, and if we can just scroll, Natalie, down to slide 16, this is example number 4. The difference here, where the retroactive extension of time, the board's position is that it cannot be granted, is in this circumstance, the prospective opponent had already secured the 4-month permissible benchmark to oppose. And again, just what we want to convey is that 4-month extended deadline, when you're dealing with Madrid applications, it's a hard deadline. The board's position is it cannot be further extended. So that's the difference between those two examples. And perhaps I'll just jump in with, there was another question here that I think relates to my section. And the question is, if we get a provisional refusal within 6 months of the advertisement of the application, can we request a retroactive extension of time and file a new statement of opposition, this time including the missing information, and move forward? And I'll just clarify, I think what's being referred to here with this question, if we get a provisional refusal, what that's referring to, I think, is if, for example, the opposition board was to reject your statement of opposition at the outset, for example, as not disclosing sufficient detail to enable the applicant to reply. You'll all be familiar with, there's an initial review process that goes on where the board does a review of the statement of opposition to make sure it provides sufficient detail and raises at least one issue for consideration. And so the question is, if it happens relatively rarely that they're refused on those bases, but it does happen. I think I perhaps can't give a totally comprehensive answer to this question, but I think the practical answer is, if you're opposing a Madrid application and you are using the template in the e-services system that we've set up, I think practically speaking, it would be very difficult to create a statement of opposition that was not otherwise in compliance with Section 38. So again, I can't contemplate here all potential scenarios, but I think if you're using the e-services template, that should be the best way to avoid the circumstance that's contemplated by this question. And Natalie, please jump in if I've misstated anything.
No, and it relates to the last question that we received, where someone asked, when we log into the opposition e-services and enter an application number that is for a protocol application, the system will automatically know it is a protocol application and the correct form will appear for us to fill in. And actually, the same e-services form is used for both protocol applications and domestic applications. You could fill out, it's the same form that's used for both. The difference is when we go to submit the MF3, the provisional refusal based on opposition to the IB, we will then pull all the information from that form. So yes, you'll get the correct form for sure if you enter in the number for a protocol application. It doesn't differ from the domestic one, with the exception of that new ground of opposition in Section 104. And one thing I also wanted to mention that relates, Tim, to your section is the way that our e-services has been set up is if you enter a number, it will tell you what actions are available. So with respect to a protocol application, if when you log in, the one action that is available is to file a statement of opposition, that may be a good prompt to check and see where you are within that 4-month deadline, because that suggests that you've already received that 4-month benchmark. And if the 4-month benchmark hasn't been received, so you're still in that 2-month advertisement period, if you use the e-services system and it pops up, it will give you both options: file an extension of time or file a statement of opposition. So if you're in that 2-month advertisement period, you'll see those options. If you've already requested that one benchmark extension, so the only extension that's possible, and we always grant the maximum, the e-services is set up to only give you the option to file a statement of opposition. So I just caution that that's a prompt that people can look for if they want to just a second prompt to make sure that extensions of time outside that 4-month window are not being requested, or second extensions of time, because the system is set up so that we grant one 4-month extension of time. So even if you were to file for a second extension of time 2 months in, that option's not given because it's only the one. And I'll see at bottom a new question. So the statement of opposition. So the International Bureau is the part of WIPO that examines the protocol applications. So the statement of opposition is sent to the applicant. And of course, the opponent receives a copy of that. The notification of provisional refusal attaches a statement of opposition, and that is sent to the International Bureau at WIPO. And scrolling through, and I'll return to section 104 of the new regulations. A question came in asking, when would be the situation that you would use section 104 if it goes beyond an international application, when the Trademarks Office would permit an amendment to that effect? That's right, amendments going beyond the scope are not permitted, but similar to challenges based on an application not having the goods and services in ordinary commercial terms. It's an amendment that's also not permitted, but that the grounds of opposition allow a potential opponent to raise it.
There was just a question here at the end about whether the slides will be circulated to attendees, and my understanding is that they will, and that the entire webinar is being recorded for future viewing. And
I see a question, section 45, if there is no Canadian agent, who will receive the correspondence? So it would be the current owner that's listed in the CIPO database. Certainly we would not send it to the IB and expect that the WIPO representative would receive it. If there's no Canadian agent, it will go to the owner listed in the database.
And just on that point, I'll note as a general point with respect to this webinar that essentially all of the subject matter that we've covered today, the basics of it, they are set out in the CIPO practice notice on opposing Madrid applications in section 45 cancellation proceedings with respect to Madrid registrations. And you'll see at the end of that practice notice, there is a quite helpful table dealing with correspondence and where the correspondence will be sent with an agent, without an agent. But we did think today's webinar was still of utility to highlight some of the particular potential pain points in when dealing with opposing Madrid applications, in addition to what's in the practice notice.
So I can take the question, can we only oppose for certain goods or services? Yes, sometimes we see statements of opposition that mention that the statement of opposition is being filed in respect of class 3 only or a certain goods or services only. However, the application in its entirety goes through the opposition process. So yes, your statement of opposition can choose to only highlight certain goods or services at issue, but the entire application will go through the opposition services. And I see a few people are raising their hands, and if you have a question, I welcome you to put it in the chat.
Natalie, given that we're coming up on 2 p.m., would you like to close things off, or did you have another question that you wanted to handle?
No, so if there are any other questions, and I think we might not have gotten to all of them, or if a few come in, we will post those answers when the recording of the webinar is posted. And I also encourage anyone who has a question they're also welcome to forward it. We do have a Madrid mailbox, and questions that are forwarded in the next few days, we can also address them with the other questions that are not answered with the recording of the webinar.
Okay, well, thank you everybody for your time today. We hope this was helpful, and have a good and safe afternoon.
Thank you.